Good morning and welcome. It's another edition of Legal Access brought to you by the McGuire Law Firm. We get together every Thursday to talk about the law and different aspects of the law. Today we're going to be talking about bankruptcy. If you have any questions about the entire process, what it means, how it works, what you need to do, what you shouldn't be doing, today is the day to get those questions answered. Call us. The phone number's on your screen, 843-848-8080. We'll get you on the air and answering those questions here for you today. First of all, to my left is Joe Wachter. And Joe, what is your firm, and do you work on anything besides bankruptcy?
I am a solo practitioner and I do bankruptcy.
Okay.
That's all I do.
All right, to your left, Margaret Evans is joining us here again. And what is your firm, and what do you, I know you work on just pretty much everything at your firm.
Well, I'm with McCutcheon, Vaught, Getty & Hux. I'm a partner. I've been there for 9 years. My practice includes consumer bankruptcy, chapters 7 and 13. I do some family law and wills and estates.
All right. And Alan Jeffcoat at the end of the table there. And Alan, besides bankruptcies, do you work with anything?
My main practice nowadays is estate planning, probate, wills and trusts, forming businesses like LLCs, and expert witness appearances.
And the word bankruptcy actually brings shivers down the spine of a lot of people. Is that is that accurate? I mean, should people be afraid of bankruptcy?
No.
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 It's unanimous.
Unanimous.
So it's a helpful thing.
Yes. Yes, it will really help a lot of the everyday folks manage their car payments, their mortgage payments if they get behind on HOA payments, things like that. It can be a way to reorganize and discharge whatever portion isn't paid through the Chapter 13 plan.
So, getting behind is one thing, but how far do you need to get behind, or how far should somebody be behind before they really think, okay, well, bankruptcy should be a good option for me?
My litmus test is if you can't repay all of your debt in an organized fashion in 3 to 5 years, then you should strongly consider filing bankruptcy.
I think the best approach for the clients I see, and if I do bankruptcy, it's going to be higher end net worth individuals or small business, is early on talk to a competent bankruptcy lawyer before you file, before you even have to file, and just talk it through. Because half of what I do in that regard is telling people why maybe they should not file bankruptcy.
I agree with that totally.
And when you file for bankruptcy, what happens? Does all your debt disappear? Is that the main advantage of that, or what happens to the rest of your assets?
If you file a Chapter 7, most of your debt will disappear if you're discharged. There are a few exceptions that are not discharged, but most of your debt is discharged. In Chapter 13, you try to pay some or all of your debt back. Depends on what you can afford.
All right. And assets, property, home, things like that, what happens to that?
With your assets, there will be some that may be exempt, some that may be unexempt. There are statutory provisions which provide the amount of exemption you can have, such as your homestead exemption, the motor vehicle exemption, things of that nature. In a 13, you are able to pay the unexempt portion of your assets through the Chapter 13 plan and keep those unexempt assets.
Mm-hmm. And I know that in the Grand Strand area we have a lot of retirees, and I heard you guys talking before we went on the air that a lot of older Americans might wait too late to file for bankruptcy if they're in their 60s or 70s, and by that time they're eaten already into their 401ks and retirements instead of saving them for their later years.
The worst thing that can happen in my book, and we talked about this a little bit, is that because retirement plans are 100% exempt from creditor seizure in bankruptcy or not in bankruptcy, unfortunately, I see clients too late in the game. They have already drained their retirement plan to try to keep things alive, and they didn't need to do that. They could have gone through bankruptcy, kept the retirement plan on the back end, and not had to pay all the extra taxes you do. So it's just, see somebody early is the mantra for me.
Absolutely. If you need to call, please do. Our phone number is on the screen. Bankruptcy is our topic here today. We'd love to hear from you. Now, I heard you guys already talk about chapter this and chapter that. I mean, that's the first thing that people hear when they hear about bankruptcies. What's the difference between all the chapter this and that as far as bankruptcies go?
When you're filing a Chapter 7, you're basically trying to get rid of your debt or discharge your debt. That's the terminology that's used. In a Chapter 13, you're paying some debt back. And how much you pay back depends on your income. It also depends on your assets. If you have a lot of equity in your assets, you may have to pay more than you ordinarily would. But so basically a 13 is a payback, and Chapter 7, you basically get rid of a lot of debt.
And an 11 is basically a 13 on steroids. It's for, because the 13 has debt limits. You can't file if your total debt is too high.
Right.
And that forces people into an 11, where you can do some great stuff, but it's expensive.
How long does it take to dig yourself out after a bankruptcy filing to get back to, I don't know, normal, if you want to put it that way?
Your credit will bounce back usually 100 to 150 points after you successfully get through your bankruptcy and get your order of discharge. So it's going to remain on your credit report. A 7 is going to be on your credit report for a period of 10 years from the date of filing, and I believe 13 is on your credit report for 7 years, I believe. Is that right? 7 years?
That sounds right.
From the date of filing. So, but creditors do tend to favor folks that have filed a 13 over those that have filed a 7, and for the simple reason that they've repaid at least a portion of those debts.
And once you've filed for bankruptcy, as far as rebuilding your credit, what are the best ways to go about doing that?
Get a debit card, get a small balance credit card, and start. If you can do, some banks will do that. If you just charge a little at a time and pay it right back, small steps.
I think part of the process of dealing with a bankruptcy client is to try to educate them prior to that discharge, help them understand about making financial plans, putting all of your costs and expenses down, learning to figure out what comes in and what has to go out. There's a lot of people that do what I call reactionary spending. I'm hungry, I'm going to go to Chick-fil-A, I'm going to go to Starbucks in the morning. They need to start learning more frugal habits and learning a new financial lifestyle.
Now I'm hungry and thirsty, so thank you. Hey, well, we're going to take a quick little break right now. If you have any questions about bankruptcy, today is the day to give us a call here on Legal Access. We would love to hear from you and love to answer your questions for you as well. 848-8080, that's our phone number here. Legal Access brought to you by the McGuire Law Firm. It's Legal Access brought to you by the McGuire Law Firm. Bankruptcy is our topic here today. If you have any questions specifically or maybe in general about the topic, please feel free to give us a call. We'll get you on the air and get those questions answered. On our panel here today to answer your questions, to my left, Joe Wachter, also Margaret Evans and Alan Jeffcoat. So we're very well equipped to answer any bankruptcy questions you have today, so please do give us a call. Now, I mean, we've been talking a lot about personal bankruptcy. As far as businesses are concerned, what's the difference? I mean, obviously, I mean, the business is different, but I mean, what's the process? Is it different?
Your 7s and 13s are dedicated to individual consumers.
Right.
A company, a corporation, or an entity can't file. I mean, I guess they could file a 7, but there's no reason to do it. Businesses can file an 11, Chapter 11, which scares people off because that's Spirit Airlines, you know, the big Chrysler Corporation,
Yeah.
big ones. But the law has changed enough with Chapter 11s, and they've got a new sub-Chapter 5 of Chapter 11, which gets confusing as can be, that's ideal for small businesses. And they can either be individually run, you can have an individual small business, or you can have an incorporated one. And you can do some great stuff under the new law for Chapter 11s, but it's expensive and complicated. I've been involved in a number of them where we've actually just saved the business by putting it through an 11.
Right.
It takes something like that, or if you got too much debt to fit in a 13, an 11 is appropriate. So you can have a Chapter 11 for an individual or a corporate entity now. Congress is kind of punted to change. They let the debt limit expire 2 years ago and haven't corrected it. So it's not what it could be, but it's still excellent
Right.
for small businesses.
If you got a small business and you have some investors that have put some money into it and you still feel like you need to file for bankruptcy, have they lost their money, or how are they, any way to recover any of that?
If you structure it in advance smartly, you can sort of protect investors and go through bankruptcy and let bankruptcy kind of clean out the bad debt or reorganize it. But yeah, one of the things for Chapter 11 is, do you have a source of ready financing to save the business? And that sounds kind of stupid in a bankruptcy context, but that's the key.
Now, I've heard you guys also talk about trustees when we were talking a little bit off the air, or when you guys were talking, because I don't know anything about this. But no, so if you file for bankruptcy, is there somebody who is overseeing you specifically as far as a trustee? I mean, how does that work? What is that?
A trustee is appointed in any bankruptcy case, and their job is to protect the pool of unsecured creditors. And so they will take a look at the exemptions that you've applied, take a look at the assets. I had a case, Chapter 7, recently where the trustee was going to take a second look at the value of the house, and I had the client do a BPO prior to filing to make sure we were okay. A BPO is a broker price opinion because the market value, if you look at Zillow or Redfin, was a lot higher than what the actual market value was because of the resales that were going on in that particular neighborhood. So they had to spend a little time and money to get that done. And of course, the trustee wanted to take a look at that, but when he saw that we had done the BPO and who had done the BPO, he was satisfied that that was in fact the correct value. But the trustees have the ability to go ahead and take a second look at what you've stated in your petition and schedule. So it's important for clients to not undervalue or overvalue their assets. You're supposed to report all of your assets, list all your creditors, and make sure that your values are on point.
I think I guess I would have a question for Margaret and for Joe, because I don't do consumer bankruptcy much anymore. But what about the Myrtle Beach, Grand Strand area is the challenge for y'all with the rapidly rising home ownership values?
Yes.
Is that different from other counties or areas?
It is. People that bought homes between 2019 and 2022, when at the peak of COVID, or right before COVID even, in that time period, the home values just shot up like crazy. And folks, I had one client that bought a home in 2017 that was worth $225, paid $225 for it at that time. When they were going to file bankruptcy, all of a sudden, after the COVID spike, the increase in the home values, all of a sudden we had an asset that was worth almost $400 or $400,000 on paper, and we couldn't exempt all of that equity. So we ended up having to go from a 7 to a 13. We had to look at both ways. I try to look at all cases both ways and see what the pros and cons are for the client so they can make the decision. But yeah, the rapid increase in the home values has definitely caused an unexempt equity issue in a lot of the cases.
I've had the same kind of experiences with my clients, a sharp increase in home values. The other issue that I see is since this is such a transient area, people are moving in and out constantly. How long have they been here? They have to be here for 2 years to claim the exemptions in South Carolina. And so that's another issue that I see a lot.
Yes, I would wholeheartedly agree. A lot of folks coming down, we have to use the federal exemptions, and if there's no emergency reason and they're a couple months from being able to use and apply the state exemption, sometimes we just wait and file when they're able to actually do that.
Right.
And
Bankruptcy, I'm sorry, go ahead.
you were asking about trustees. It's sort of funny. Each one of the main chapters has trustees. Chapter 7s, 13s, and 11s. The 7s, their job is liquidate in favor of you keep less in a 7, but they take a hands-on role with the 7. With the 13, my impression is they are more a conduit to payments and have a more limited role. When you get to an 11, there's a provision under subchapter 5 that says, yes, you get a trustee, but that trustee's job is really to try to work it out, mediate everything and bring the parties together. A very different role for the trustee.
Bankruptcy is our topic here today on Legal Access. Still got about 10 minutes left in the show. Got plenty of time to get you on the air, so don't wait any longer. Our final segment is coming up in just a second. Give us a call. The phone number is on your screen, 843-848-8080. Give us a call right here on Legal Access, brought to you by the McGuire Law Firm. It's Legal Access, brought to you by the McGuire Law Firm. Today we're talking about bankruptcy. If you have any kind of questions about the process in general or something specific that's going on with you or a family member, please feel free to give us a call, 848-8080. That's our phone number as always. On the panel here today to answer your questions, to my left, Joe Wachter, also Margaret Evans, and Alan Jeffcoat. So again, we're very well equipped to answer all your questions. I saw a stat a while back that the number one reason that people file for bankruptcy is medical bills piling up. Would you guys agree with that, or is there other reasons that are on top?
I think that's one of the main reasons. Another reason people lose their jobs, so they don't have an income source. But debt piles up. A lot of times people don't use their credit cards very responsibly. They charge way more than they can pay.
Yeah.
So there's all kinds of reasons, but medical bills is certainly one of them.
Talk about student loans and where that is. I'm not involved with those so much, but it's been a big drag on the economy with the student loans being generally not dischargeable.
They are generally non-dischargeable. I haven't done any adversary proceedings regarding student loans to this point, but I'm following some other states and seeing what they're doing, and there's becoming a process where you can get a discharge, but the general rule is still no, you can't. But they're slowly opening up other pathways to allow some relief from student loans.
Let's go to the phones right now. We have Deborah in Conway on with us right now. Deborah, hi, thanks for calling in here today. What's your question for the panel?
Yes, thank you. I am extremely in debt, and it's credit card debt, trying to pay for medicine and groceries and all that. My question is, is it just better to let that all go because my credit's already bad, or should I file bankruptcy?
Well, that's going to depend on the type of assets you have, how much equity you have in your home. It's going to depend on a variety of factors, those probably being some of the most important. If all of your equity is exempt, then a judgment wouldn't pair the exemption in a bankruptcy, and they couldn't get to that equity. So it would be important for you to speak with a seasoned bankruptcy attorney who can do the analysis and give you that answer.
All right, Deborah, thanks for calling in. I appreciate that. And if you have a last-minute call, just like Deborah, we've got about 5 minutes left in the show or so. We've got plenty of time to get you on the air. 843-848-8080 is our phone number. And Margaret, I know that you also work with divorces. I mean, if somebody gets divorced and they file for bankruptcy after a divorce, how does that affect their alimony and or child support?
Alimony and child support are considered or labeled DSOs, which is domestic support obligation. Those are non-dischargeable in bankruptcy, so those would have to continue to get paid. Now, I have used a Chapter 13 for some clients in family court, where if they are getting ready to go into a rule to show cause for alimony or child support that's been unpaid over a period, we can save them from going to J. Reuben Long by filing that emergency 13 and getting them some relief. And we'll have to get that unpaid or arrearage paid through the plan, but we can successfully do that often.
And during one of the breaks, I heard somebody use the word cram down. That doesn't sound like something that would be a legal term, but apparently it is. What does that have to do with bankruptcies?
Cram down. That's a term of art that bankruptcy lawyers use. For example, if you purchased a car and financed it 3 years ago, it's worth $10,000, but you owe $25,000 on it. As long as it's been over 910 days since you did a purchase money security loan, you can cram down that value. In other words, you're going to take the portion and repay the portion that is secured, which is the $10,000, and the other $15,000 that you owe that's above the portion that's above the equity, that will be treated as unsecured non-priority debt, which means the creditors are probably going to get pennies on the dollar for that portion of the debt of the car. So you can save a lot of money.
In a chapter 11 on that same word,
Right.
cram down, which sounds nasty, but it's very useful. Chapter 11's the creditors have a voice. They get to vote by classes and all that. And if you've got a situation with a creditor that's just giving you a hard time, is not going to consent to anything, you can use the cram down there to say, we're doing this to this creditor and you don't get a vote.
Right.
You know, that's very useful in that kind of bankruptcy.
I think Deborah has a follow-up question to her original question. Deborah, thanks for hanging on. What's your follow-up?
Yes, the lady was talking about assets. Well, I have nothing. I mean, I have absolutely nothing. I live from Social Security check to Social Security check. My little Volkswagen Bug's paid for. I have absolutely nothing. So should I do the bankruptcy or just let everything go and forget about it?
Well, what do you rent or do you own your home?
I rent.
Now, if you rent, you probably are judgment-proof. If you're a judgment-proof debtor, then you might be able to avoid filing.
How about
Yeah.
imminent medical expenses? That might affect the timing. If
Yeah.
they're about to go into an operation or
That's
whatever.
true, yeah.
Deborah, sorry that you're going through all this, but thanks for calling in, and hopefully that's helped you out a little bit. As they said, make sure and give somebody a call, give a bankruptcy attorney a call, and they'll be able to talk you through a little bit more with all the details that you can give them. What if somebody tries to take advantage of the system and goes out and runs up their credit purposefully, and then comes back, in a month and says, "Hey, I can't pay my bills"? I mean, does that affect anything, or is that something that people actually do?
Yes, that would be considered bankruptcy fraud, potentially, especially if they're buying cruises and fancy jewelry and what would be considered luxury items. If they've purchased a cruise, then they're going to have to wait at least 90 days before they can go ahead and file. You're not supposed to be running up debt within 90 days of the date you file. Now, if you had to...
Now, as far as filing multiple bankruptcies, if somebody's already filed a personal bankruptcy, how long could it be until they file again?
I believe it's 8 years from date of filing between 7 and 7. 4 years between 13's date of filing to date of filing, and I want to say it is 6 years if you're doing 7 to a 13, but I'm not,
Right.
I'd have to go back and look at the rules. I can't remember that one off the top of my head.
Tell you what, that's all the time that we have for our show here today. Appreciate you watching as we've been talking about bankruptcy. Next time we get together next Thursday, we're going to be talking about personal injury. If you have any questions about personal injury, make sure and give us a call next week, Thursday between 11:30 and noon, or you can email us in advance, legalaccess@WMBFnews.com. For Joe Wachter, Margaret Evans, and Alan Jeffcoat, I'm Dave Priest. See you again next Thursday right here on Legal Access, brought to you by the McGuire Law Firm.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by an attorney, you should direct all legal questions to your attorney. The nature of any legal